What's going on, everybody? I wanted to go over something that is very important, that some of you guys may need to know and understand. And the reason why I'm going over this is because once people understand this, in my opinion, it should change the dynamic. And I don't even know what I'm gonna wear today, so I'm gonna get to that. But I want to talk about the case styling and designation of a case and why it's important and why it can actually get your case thrown out. Now, a lot of times when we go to court, we don't understand jurisdiction, okay? And we don't understand how to make a court prove that it has jurisdiction. So the styling of a case, meaning how it's styled. So if you've ever filed a court case or you've ever e-filed a court case and you actually went into the system, you will see that there is different designations for cases. Like some may be personal injury, some may be criminal, some may be civil, some may be let's see, for UCC, etc. When you style a case or when you designate a case, this is the most important aspect. Now, when I tell people stuff like how you got into court is the way that you get out of court, or how you got into something is how you get out of it, this is what I mean. So when people style a case civil or criminal, and it's that is vague. So if most of you don't understand, most of you may have not known about the vagueness doctrine, or if you read the vagueness doctrine, we'll go over it and I'll go in and explain it to you in depth. But when a case is captioned as civil, when they're alleging that you breached the contract, that may be just enough to get any case thrown out. Because when you're suing somebody, you have to be very specific. Okay. So in a civil complaint, it must clearly state a specific cause of action, like breach of contract, negligence, or fraud. Just not just civil dispute. That's not enough. Okay. So if the case doesn't say how you broke a contract or what you violated or what specific harm they suffered, it might be too vague to stand. So when you're reading your complaints, and they'll say so and so signed a contract on this day. So and so signed sped, so and so did blah 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 on this day, right? What people allow is that they allow hearsay, they allow hearsay on top of hearsay and evidence, and then they wonder, like, why do I lose this case? Okay, when you allow a lot of void, vague, ambiguous terms, allusions, or someone alluding to a breach of contract with no evidence that they ever put up the collateral or the capital, you're in a situation where the person has failed to state a claim which the court can grant relief for. Okay. Like a lot of times you'll get traffic tickets, but there's no attachment to those traffic tickets. There's no affidavit filed into the court. There's no complaint filed into the court. Okay. A lot of times you guys do not challenge that, and that causes you a lot of hardship. Okay. So look, when a person captures the case and you see you're sued and you look at the caption and or the filing of the case and it's civil and it's not breach of contract, you can challenge that. Okay. So I'm going to get over here to where we're talking about case styling. So in legal context, case styling refers to the standardized formatting and presentation of citation case citations in legal documents, including court filings, briefs, and scholarly articles. Here's a breakdown of what styling entails. The purpose of case styling: clarity and consistency. Standardized formatting ensures clear and consistent identification of cases. So that means if somebody just styles your case as a civil case and then they put it in this court, the court may not be able to hear it because you can object to say that this court is not able to hear this, whether it could be for venue or other reasons. Okay. So clarity and consistency. Okay. Professionalism, adhering to recognized style guide enhances the professionalism and credibility of legal writing. Key elements of case styling. Case name. You're going to see this in a lot of cases. Miranda versus Arizona. The name of the case, typically including the name of the parties involved. Reporter, the publication where the case is reported along with the volume and page number. So a lot of you guys don't know that these cases have to be recorded. So you can ask them, where's the volume and page number? You can ask this under discovery if you want to know. And if they cannot prove that this case is recorded, you're being fleeced. I'm telling you some invaluable information. So a lot of people don't know that this has to be recorded too. Cases have to be recorded. And a lot of them are recorded in the register of deeds or with the circuit court. Okay. So court and jurisdiction. The court decided that the case in its jurisdiction, 1966, the year of the decision, the case was decided. Okay. So they're talking about, this is basically like cases where that have been decided. Okay, under Rule 12b-6 of the Rules Civil Procedure of your state's version, you can file a motion to dismiss for failure to state a claim. Okay, if they're suing you and the case is filed under civil and it's not filed under civil breach of contract, well, what people don't understand is that the court really goes off the record. Okay, they don't go off of all of the documents, the pleadings, and all of that stuff. That's for hearings and trials. Okay, so if you don't understand that, then you're not going to really understand what's going on in court. Okay, when a case is missing facts or disguises itself under a generic civil label without a clear cause, you can challenge it and win. Okay, so if somebody drug you into court just because they filed some papers, make them prove their claim or get it dismissed. So a lot of times when people go into court, they just allow people to do vague stuff. So I'm going to go over and I'm just going to basically put this in AI so you guys can verify it on your own and do your own research. Okay. So what I asked the AI as a question is, if a civil case is classified as civil in its styling and it's a breach of contract, can a person challenge it? And the reason why is because I already know this. You can challenge every aspect of a court case, every aspect, meaning the styling of the case, if it's civil or if it's really criminal. You can challenge if it was actually should be tried as a breach of contract case without them actually having evidence of a contract. You can challenge all of these things. So, yes, a person can challenge the designation of a civil case as vague and argue that it should be specifically tried as a breach of contract, specifically if the underlying issues involve a contract dispute. This is because the specific legal framework and remedies applicable to a breach differ from those applied to broader civil claims. So you hear things where people are telling you, like, oh, when you go into court, they're doing this. It's because they're suing you in a vague title. And this vague title allows them to operate with impunity inside of it because civil does not specify to one cause of action. You have to make them sue you under a cause of action. Otherwise, if they apply the law liberally under a civil suit, then you're going to be in a grave disservice because you're going to be basically subjected to a immense amount of legal speculation. Okay, this is what gives the judge too much wiggle room to do what he wants to do in court. Because if the court is going under the rules of civil procedure, that is a lot of rules. But if the court is going under a breach of contract, now we can dance because all of us know the rules. We all know what is the elements of a breach of contract. We know what I need to prove and what needs to be disproved. You see what I'm saying? So when you're sued civilly, your rights are being violated. Okay. If you're being sued criminally and they have not proven an injury, then your rights of due process are being violated. But it's not even the fact that they sued you criminally, it's the fact they never serve you in a criminal lawsuit. That's the whole crux of the issue. But in a civil, this is mainly for civil, okay? Even though all things are civil because they all are lawsuits, they all have to initiate as a lawsuit. It's the classification or the styling of the filing that they try to use as a quasi traffic, quasi. You're really being sued civilly. You're always being sued civilly. So that means that the rules of civil procedure, meaning you have to send notice to the other party, always apply. That's why I tell you guys that. But if they're suing you civilly, right, you can challenge that because that's vague. So they failed to state a claim without, where the court can grant relief because they're suing you civilly. Okay, they have to have a specific cause of action, and that has to be docketed and documented, and they have to have proof that they recorded it. So you need to get a book page number. If they did not do that, you already know what your recourse is. And with that being said, everybody, I want you to have a great weekend, a productive week, and have a great day. I'm out.